So today's cardinal lesson, we put a Y in the title, Why Estate Planning. And so we're going to be talking about some of the things we do in our financial planning practice for just about all the people that walk through the door and hire us to do financial planning. We're going to emphasize the necessity of doing estate planning. And so why are you doing this? Because you don't want to leave behind a mess. And we're going to give you some examples today of some of the messes that have been left behind. We're going to talk about probate. We're going to talk about what happens when people die intestate, where they don't have a will. And we're going to talk about some ways to bypass probate. And we're going to finish with talking about some of the documents that you need to put in place. So I want to put Tom on, and I want Tom to talk about why we're doing this video today.
Yeah, I mean, I think you said it right. It's to plan for, not leaving a mess behind, right? I mean, we'll get into some examples, but if you don't plan for this, your family is going to have a hard time, and it's going to be complicated. It's going to be stressful. There's going to be fighting with each other, and we want to avoid that. So we want to give you sort of the tools and things to think about of how to plan there. I'm going to pull up the show notes here. They're at the link below our video. They're also on our website. Again, it's not, we have the board. There's a chapter. So Hans wrote a book, The Complete Cardinal Guide for Planning for and Living in Retirement. One of the chapters is about estate planning. So we really just put in the chapter there so you can read through that if you're interested. But mostly we're going to stay on the board, give you some examples, give you some things to think about, ways to help avoid these issues. Because if you don't plan here, your family is going to have a real difficult time after you pass.
Okay, so I mean, first of all, what is probate? I mean, probate, it's the legal process of executing a will. It's that dreaded process after a person dies where their will is taken by a person, the executor, and lobbies the court to execute the will. And it's the whole process around that. And probate is expensive, it's time consuming, and it's there for the public to read about. And so because I'm in the estate planning business, I tend to read about all the celebrities who pass without a will. And a lot of you may not know Aretha Franklin, Prince, Larry King, Abe Lincoln, James Gandolfini, Tony Soprano. He was 49 years old, left no will. I mean, I could go on and on and on. And I'm not going to tell you about the mess they left behind, because you can go look it up for yourself. You just Google any of those names, or you just Google a list of people who, celebrities who passed away without a will, and you can read all the dirt you want in there about their families fighting and different areas and delays and attorney's fees. And some of those estates, I think Abe Lincoln's estate is settled by now, but I think Prince's is still, the government took 40%, the federal government, and the state's going to take about another 10. Of his $250 million estate. And that's all for people like me to read and to learn from. But you don't want your family's mess, if there is one, there for all the public to read. So the probate process is expensive, very expensive, because you got to hire attorneys to go through that. And there's really no way to avoid it if you have real estate and you have some things that can't be bypassed in the will, but it's really a bad thing to have all of your assets tied up in probate where your family can't even get it, some of it, just to pay your bills. So we're going to talk about some ways. Well, first of all, before we talk about bypassing, we're going to talk about intestate. And each state has their own laws of intestacy, but what intestate is just dying without a will. So, and the good news here is that the state's written a will for you. So you live in a particular state, like, I have an example of one in Virginia where the surviving spouse, if there is one, gets 1/3, and the surviving children, natural children, get 2/3. And I mean, we have an example of somebody that we went through this, and then these were stepchildren. The whole thing was just a mess, and we helped them work through it. But stuff is going to be tied up for a long a long time when people die intestate. And you're going to be subject, or your heirs are going to be subject to the intestacy laws of the state. Now, we want to talk about some ways to bypass probate. And we do this with our financial planning clients, where we're going to go through everything they got and we're going to find anything and everything financial that has a beneficiary on it. And we're going to check where it is now and how it's stated now. A lot of people say, oh, that's all taken care of, it's all fine. And even after people tell us that, when we get everything out and we read it, a lot of times it's not the way they wanted it. Okay. And that's going to include every IRA and 401k. It has a beneficiary on it. It doesn't have a beneficiary, it's not an IRA or a 401k. Life insurance policy and annuity policies. We have some people that buy annuities just for the beneficiary designation because the money's there. If they need it while they're alive, they can get at it. But it's primarily they want to make sure that it goes to who they want it to go to, bypassing probate. And that can be one of their main reasons for buying an annuity. And same thing with life insurance, is we start at the beneficiary and we work backwards. But for people that are watching this, you can go in and you can make a list of every life insurance policy, every annuity, every IRA, and every 401k, and you can check the beneficiaries many times online and see if they're exactly who you want them to be. And a lot of times when I have clients come in and they are working with us, they'll perhaps interrupt me when I'm going through this, and they'll say, oh, that's all taken care of. And what's all taken care of is they redid their will. They redid that sometime before, and they laid everything out. This is a lot with second marriages where people have gone in and redid everything, but they didn't go back to the beneficiaries and change them. So all these beneficiaries are a great thing. They bypass probate, but we need to make sure the beneficiaries in the will are lined up. In other words, the beneficiaries need to be who you want to get what. And then there's such a thing as contingent beneficiaries in case the beneficiary is deceased before you are. Then we've got transfer on death, and this is pretty not used a lot. It's underutilized, the TOD. And so when you go in and open up an account at the bank, many times they don't just pop up a screen that asks you got to ask for this. But you can do, it's very similar to a beneficiary designation where it tells the bank or it tells the stock brokerage or the custodian what to do with the money when you die. And all they need is a death certificate, and it's just like a beneficiary. They're going to pay off the heirs according to this. And this is going to happen a lot of times way before this does. So by the time they get around to executing this, the money's already transferred. So, and then another way to bypass probate is a trust. So, and this is what some people do, is they move most of what they got into a trust. And this works particularly well with real estate. And then it'll pass outside of probate after you die. The trust will just take over, and the trustee, and they'll distribute things to the beneficiaries of the trust. You know, and I say that with a little bit of reservation because I don't want everybody running out and setting up trusts just for that reason, because many times there's a way to plan around that. Now I want to bring Tom on and really hear what Tom has to say about these three things.
Yeah, I mean, I think the point we want to make here, we listed a bunch of the celebrities that this happens to, but this also happens a lot of times just to regular people. You don't have to be rich and famous for this to be a problem. I mean, you could have a much smaller estate, and this could cause all sorts of headaches. I mean, I have a client right now whose dad, they owned a small business. The son was working in it, really running the business at this point, and was intending to take over the business. Well, dad gets married, to a longtime girlfriend. A month later, he unexpectedly dies without a will. Now, like Hans was saying, a third of his estate, including the business, goes to this new wife. I mean, that was never the intention, right? So if you don't plan for this and you don't have your will set up and you don't have a plan of what happens to all your money when you pass away, the state is in charge of it. And oftentimes it goes to people that you're not intending for the money to get to. Now, you'll be dead. You won't know this is going on, but your family sure will. and your family are going to have the pieces to pick up after sort of they're put into this crisis situation. So, it's not a lot of fun to think about what happens when I die, but I'll tell you, I mean, we see this all the time, is you have a lot of sort of a relief when you get this done. There's just a weight lifted off your shoulder after you've done the planning, you get the documents set up, you've done the right things, knowing that your kids aren't going to be, it's not going to be a mess for them to pick up the pieces when you pass. And so this is for everybody. Everyone needs this. It's not just the rich. Everybody needs a will. We'll get into the other documents in a second. It's not just a will, but I also just want to hit on that point again, like Hans was saying, is anything with a named beneficiary passes outside of the will. It passes before the will is even executed. And so, a lot of times we hear, oh, I got that taken care of. It's in the will. It's like, well, let's check again. Let's make sure this is right. We can't tell you how many times we've seen ex-spouses listed as beneficiaries. People that, brothers or sisters before they got married, they listed as the beneficiaries, or before they had kids. All sorts of things that can be wrong, and it happens outside the will. You got a problem there. And so we just need to look at it. We need to make sure everything is going to happen the way you want it to. And once you're done, you'll have this sense of relief that the planning is complete.
So when we bring in new clients for financial planning, we ask to see this stuff. And so if you've already done it, we'd like you to send it to us along with your financial statements. We have a way to do that on a secure portal so that we don't have to send them over email. But we're going to read this, and we're going to have the attorney, if necessary, that works in conjunction with us, read the existing documents that you have. And we're going to make sure that they're in line with what you tell us you want to have happen. Okay. And then we're also going to get you to pull out all the beneficiaries on everything you got. And if necessary, we're going to make some changes on those, because like we said, when people already have the will done and they've already got the beneficiary done, we find some conflict there. We find some differences, and the beneficiary designation is going to win every time because it's going to be distributed before anybody even reads the will. So now I want to talk about, and as he said in the show notes, there's a chapter in my book. It has a lot of these same themes that we're talking about in there. But the four things that you need, and for a couple, in certain states, we can provide this service through an attorney. I mean, we're not attorneys, so we don't draft these documents, but most people, it's just the basic, if they don't need a trust, are going to be well off to have these four documents. And we can provide a service of hooking you up with an attorney that we're affiliated with that isn't going to charge you an arm and a leg to draw these things up according to your wishes. Now, the last three end at death. So, number one is for after you die, the will. And 2, 3, and 4 are while you're still living and you're incapacitated, you're not able to make decisions for yourself in your best interest. So now you're legally giving authority to perhaps one of your adult children, to your spouse, to somebody from your church, so a very trusted individual to make these decisions for you. This gives them the legal authority, durable power of attorney over money, a healthcare power of attorney over healthcare decisions, deciding whether you're going to get home health care or assisted living, making a deal with a doctor, negotiating. The doctor wants to go through decisions. This is a very critical document. And then the HIPAA release, which the HIPAA is, people say, I already signed that down to the doctor. Okay, just hang on a minute. That's great if you already signed it, where you're releasing this, but what we want is that many years from now, perhaps, or sometime in the future, when you're not able to make decisions, we want somebody who's still alive, it's nice if it's somebody younger than you, is able to go to your doctor, see your medical records, pay your bills for you and all that kind of stuff. And they're going to just have a general release for HIPAA that they can hand or email to any medical provider, that sort of thing. So what's important to note is you need all four of them, but 3 of them end at death. And then the will just states what happens to your stuff. and the order of that, and the will has to be probated. So what we listed here is pour over. So when people do financial planning with us, we're gonna just have them distribute as much as can be distributed by beneficiary and bypassing probate. And then the will is simply going to be a pour over or a catch-all for whatever wasn't caught by that. And many times it's real estate needs to go through probate. And then in some states, there's things you can do with real estate to bypass probate. So we'll wait, in the advanced course that we'll kind of get into that stuff. So again, I want to bring Tom back on to talk about these 4 documents and getting an attorney to do that. It's 8 documents for a couple.
Yeah, I mean, I think Hans made a really good point. Is like the power of attorneys; those end at death. So I have a client right now whose mother just passed, and they went to go do some transaction in the bank account. The bank said, "No, we can't do it. Your mom has passed." I said, "Oh, we have power of attorney." Doesn't matter. At death, that account gets locked down. That document has no more power to do anything, and so that ends at death. Um, One way to solve that, if they had thought about this or the mom had thought about this ahead of time or known about it, is that TOD, that transfer on death, is a way to have that account passed directly to whoever you name as that person without giving them control over the account. They don't need to be a co-owner on the account. They don't need to have access to the account. It purely just acts like a beneficiary that upon my death, now I give them the account. And that is a way to bypass probate. Like Hans said, a lot of banks, they don't really talk about this. Most banks have the document if you ask about it, but it's not something they really, bring up on their own unless you inquire about it. So that would be something that would be very easy to do. Just fill out a form, name the person there, and that's another thing we can get outside of probate, have it passed much more quickly. Probate takes time. Oftentimes you have to hire an attorney to do it. It's expensive. So anything we can have pass outside of that is going to be very advisable. So I think that's important. And then, like John or Hans said, the will, that's really the catch-all document, right? The goal here is to get as much to pass outside of probate as possible. And then if there's anything that's missed, if there isn't you didn't name something on the form or you didn't, properties a lot of times has to go through this. It's not terrible to have some things go through probate, but the more we can minimize that, the better off it is, and the smoother the transition will be upon your passing.
Okay. So estate planning within the context of holistic financial planning and retirement planning, we got the 7 subjects, and this is just one of them, but we're going to touch on 1, 2, 3, 4 of them today. Long-term care, because we talked about really when you get needing care, you're going to need to have definitely number 2, number 3, and number 4 in place for whoever your caregiver is. And even if your adult children are not providing the care, which I hope they're not, they're going to need these documents just to do business with the people that are providing the care. 401k IRA, we do a lot in our financial planning of just making sure that all that flows to the right people quickly by beneficiary, but there's different beneficiaries. I mean, the spouse is the best person to name as the beneficiary because, first of all, they need it after you die, the surviving spouse, but then secondly, they have the most tax advantages in terms of how they distribute the IRA money versus kids or somebody else. But anyhow, we covered that today. Estate planning, and then of course taxes are a part of everything we do. So I want to bring Tom back on. I'm Hans Scheil. We thank you very much for listening.
Thank you.